My name is Michael Peter Mayoral. I'm one of the two shareholders and founders of Perez Mayoral PA, a law firm in Florida dedicated to representing homeowners against their HOAs and condominium associations. Before we start, as I am a lawyer, I need to read some legal language and a disclaimer, so please bear with me and we'll get through that. So I want everyone to note that the information provided during this webinar is intended for educational and informational purposes only and does not constitute legal advice. So participating here in this presentation does not create an attorney-client relationship between us. Hopefully we'll have one in the future, but not today as a part of this presentation or with any attorney here at Perez Mayoral PA. While we've made every effort to ensure the information here is accurate and reflects current Florida law, it's not a substitute for consulting with a licensed Florida attorney about your specific situation. Every situation is different and fact dependent. It's an evidence-based justice system, and the evidence dictates what people's rights and abilities for relief are. So that's going to depend on your specific situation. If you have questions about a particular legal matter, we encourage you to consult with our office or a licensed Florida attorney to discuss that situation. But we'll go ahead and start. Okay, so today's presentation is Florida's new condo laws and what they mean for your future as a homeowner. Okay, as you may know, recently Governor Ronald DeSantis signed in House Bill 913, which changed some laws with regard to both the post-Surfside litigation and certain corporate governance of HOAs and condo associations, and that's what we're going to be going in through today. So the first thing we'll go into is the purpose of it. Okay, so this law, in the speaker's opinion and after our analysis, provides relief from some of the burdensome post-Surfside regulations, and it adds in a lot of key reforms to improve safety, transparency, and governance. In terms of relief, it eases financial pressure on associations and owners, which we're going to go into in depth. And it extends compliance deadlines, provides flexibility for reserve funding, creates certain exemptions for smaller buildings so they won't have to be under, the post-Surfside regulations, and create some temporary relief mechanisms for both completing repairs and funding reserves, which we'll go into in depth as well. As to reform, okay, it's expanding owner rights and access to information. Okay, it's enhancing board accountability. We're modernizing voting and meeting procedures, which is a great and very necessary thing down here in South Florida, and strengthens oversight of property managers, which was much needed, and I think will be an eye-opening part of our presentation today, and improves safety standards and insurance protections. Okay, so to know where we are, we kind of have to know how we got here, okay? And what's important to know is the law before the Surfside Towers tragedy and after are different, okay? So before Surfside, before that collapse, okay, milestone inspections were limited to Miami-Dade and Broward County. So what's a milestone inspection? It's a periodic inspection after a building has aged a certain amount to check for structural issues within the building. And before Surfside, only two counties really had this system in place, Miami-Dade and Broward, leaving the rest of Florida with little to no oversight over aging buildings. Buildings were inspected at 40 years old and every 10 years after, okay? And there was no statewide inspection mandate. Okay. More importantly, reserves could be waived. Okay. Now, what are reserves? I really like to break things down to the easiest level. I don't like to assume that my listener knows what all these terms are. So I apologize if I tell the audience something they already know. Reserves, for the purpose of this conversation, are the same as reserves in any business or operation. Businesses typically hold some reserves. That means money in their account in case they have to cover payroll or have certain expenses. It's money you hold to pay for expenses down the line. Buildings, too, if you think of a large multifamily building, have things that they're going to have to potentially pay for down the line, repairs, maintenance. So the standard practice is to have reserves, to hold reserves for anticipated maintenance. Before the Surfside collapse, buildings were allowed to waive reserves, to not require them. Okay. And there was a certain lack of owner transparency as to engineering reports. Often these stayed with boards, and there wasn't written into the statutes of them having to provide it. And many buildings age for decades without, professional structural oversight. In the case of the Surfside Towers, Structural problems were identified and postponed, and some argue that this is what led to the collapse. Okay, so post-Surfside, what happened? And on the left there, you'll see it's a fascinating ad. It's when the Surfside Towers were built. Uh, Location or luxury, Surfside Towers has both. And many of these buildings offer that, these coastal buildings offer location, luxury, and are filled with board members or unit owners who are really trying to do their best, struggling with a full plate, managing a large multifamily building and the structural issues that affect a coastal building. So after the collapse, what did the legislature do? They acted as quickly as possible to enact reform to make sure that these buildings were safer. They don't want to see another collapse. Okay. So what were some of the legislative changes? Now in Florida, post Surfside, all condo buildings 3 stories or taller. Now, the new law changed that to habitable stories, and we'll get into that, must undergo structural milestone inspections at 30 years or 25 years if they're near the coast, and every 10 years after. They also require reserve studies, a structural integrity reserve study. It is a study to determine how much reserves a building should have to deal with their structural integrity issues. Associations now must perform those every 10 years periodically. Okay, and no more waiving of key reserves. Owners can no longer vote to skip savings for major components like roofs, foundations, and waterproofing. Okay. Also, increased transparency. Inspection reports and reserve studies have to be shared with owners and included in resale disclosures. And some board and manager accountability. Board and property managers, they changed the law to make it so they have much more accountability. They have to sign on affidavits that they've received these documents, structural integrity reserve studies and milestone inspection studies, and they have more accountability for both receiving them and completing the repairs, as we'll see. So what happened then? So what happened post Surfside that we now need a relief bill? We had a building collapse. We had a legislative change to add safety components to the law. So what happens now that the law needs to give relief to that? It's a fascinating problem, okay? So this is what happened. All of a sudden, all of these buildings were hit from 3 or 4 angles with 3 or 4 competing factors. First, there's a chain reaction that happened, okay? These things were, let me start with the slide, necessary but costly. The new laws address major safety gaps but placed sudden financial pressure on all of associations under a blanket system, okay? Most buildings, or a lot of buildings that had not been complying before, had to catch up and suddenly fund reserves fully, okay? They had to undergo milestone inspections, okay? And they had to conduct reserve studies. The studies and the inspections cost money themselves to complete, but they then have to comply with them, fund the reserves, do all the repairs, which in a perfect world makes sense. Yes, fund repairs, fund the reserves. What's the problem? The problem is that money has to come from somewhere. And in the context of an association, it has to come from the unit owners. And a senior citizen living on a fixed income is not ready to shell out a $10,000 special assessment, a $100,000 special assessment that we saw in South Florida last year. So they're not ready to fund it. So what else is happening? You have the urgency to fund repairs. Okay. You have the insurance crisis at the same time. A condo unit owner has a hell of a problem selling their unit if the building cannot get insured, because no conventional buyer with conventional lending is going to approve a sale into that building. So you have the pressure of both people not being able to sell their units to get out of it. Okay. You have the pressure of them then needing to fund the necessary repairs, and then the double pressure of not only fund the repairs, but fund all of your reserves at the same time. Okay. And you have the issue that we'll get into later, that many of the engineering firms conducting the milestone inspections were also bidding on the work. And there was a problem of inflated work. And this is a deeper challenge that we have here on the right. Most associations have faced a huge challenge during this whole change. They need to negotiate fair repair contracts. They need to vet vendors and manage major construction with limited resources. Okay, so that's created quite a crunch, and this is what the legislator did. They created a relief bill from their own bill, essentially. So it has a dual purpose, though. Okay, part of it is relief for associations, extending deadlines, alternative funding options, temporary relief mechanisms, and other things are to enhance and help out unit owners. So in my opinion, the legislature really tried to help out homeowners here. Does it need to go further? Yes, but very good intentions in my opinion. Okay, so today we're going to go over structural and safety and structural requirements, reserve funding changes, governance improvements, financial transparency and record keeping, CAM license and management regulations, and electronic voting and video conferencing. Okay. So first, safety and structural integrity reserve study requirements. Okay. So what is a structural integrity reserve study? Okay. It is an engineering-based evaluation that identifies key structural components of a condominium and estimates the cost and timing of future repairs and replacements. Imagine if you're a single-family homeowner and the Florida, legislature puts in place a law that every 10 years your home has to be inspected by an engineer and to determine how much reserves you should hold for the next year to fund possible maintenance on your home. Okay, on a single family home, you may not have that many issues, but a large multifamily building, especially a coastal building, you might have a lot. So what does it include? A visual inspection of the structural elements, the remaining useful life estimates for each component, the estimated cost to repair and replace each item, and the recommended annual reserve contributions to cover those costs. Okay, why does it matter? In principle, it's a great idea and it should be done. It ensures associations to plan ahead for major repairs. It helps prevent deferred maintenance that can lead to safety hazards. This was arguably part of the problem in Surfside. There's always a tug of war in a building between necessary maintenance and the funding of that. So, in a perfect world, every building would be maintained perfectly and assessments would be as low as possible. But this is the to and fro that happens. So this is what a reserve study does, is to make sure you have the money so that those repairs don't not get done due to a lack of money. Okay. So, and this is required by Florida law for all condominium buildings of 3 or more habitable stories. Okay. Habitable means excluding parking garages and stories that are not being used for homes. Okay. And like we said, these amounts cannot be waived, but there are some modifications with the new law. Okay. So what did the new law do? We extended deadlines. We're going to go over this over a couple of slides, okay? We extended deadlines to complete the structural integrity reserve study, okay, to December 31st, 2025. Okay, why was this done? A lot of associations just still have not complied, in my opinion. Okay, the definition was clarified. Okay, so they said that this requirement, these requirements to do all these procedures now applies to buildings with 3 or more habitable stories. Okay, parking levels do not count towards the 3-story threshold. Why is that important? They're trying to take smaller buildings out of these requirements. Why? Arguably, smaller buildings don't have the same structural concerns that larger buildings do. I'm not an engineer, so I can't opine on that, but that appears to be the thinking. Okay. And the other mechanism that's in place is that if structural components are repaired or replaced, the structural integrity reserve study can and must be updated accordingly. What does that mean? If a structural integrity reserve study says that they must hold, association must hold $2 million in reserves, and then the association goes and repairs certain things, they can and must update that reserve study to make sure that the reserves are only in place for things that actually need to be replaced. So it gives associations some flexibility with how to lay out the funding of those reserves. So this is more of the same, okay? So this is really to explain this a little bit more clearly. So the delay option, If a milestone inspection has already been completed, that means somebody already went through the property engineer or architect to determine if there's major structural issues, then associations may defer the performance of the structural integrity reserve study for up to 2 budget years. Again, if you as an association have already done the milestone inspection, okay, you could delay the performance, the hiring of someone to do the structural integrity reserve study for up to 2 budget years. So this allows time to prioritize immediate repairs before commissioning the reserve study, and it's designed to ease financial pressure and avoid overlapping costs. A personal friend of mine, his father's just a very smart businessman and sits on the board of a couple condominium associations. And what he told me is the best thing that they have done is continually repair the building. So you don't go into a structural integrity reserve study with a lot of stuff in disrepair and then have to fund a huge amount of reserves. But for all intents and purposes, it's within a condominium association interest to continually do maintenance on a building, just like you would on your home and your car. You know, with your car, if you don't do maintenance and it's just wait, you're going to have to pay the price. The problem's going to get worse. It's the same with a building. Okay, the best practice is to continually do repairs. Okay, the update requirement, again, if things are repaired and replaced, the structural integrity reserve study must be updated, okay? And board accountability with regard to this, the association must sign an affidavit. The board members must sign an affidavit confirming they received and reviewed the completed structural integrity reserve study. That's in place. So believe it or not, some boards in Florida refuse to do these things, refuse to do any repairs, refuse to have insurance on their building. We've represented multiple people, but recently someone who's their board president decided, we don't need insurance, which makes every unit almost impossible to sell. And this is something that the legislature changed as well with this bill. All right, this is one of the most interesting aspects, in my opinion. The conflicts of interest protections. Okay, this was put in place with this year under HB 913. So what did HB 913 say as to this? What they said is engineers who are performing the safety inspections, the milestone inspections, must now tell associations upfront if they intend to bid on the repair work they might recommend. Okay, so listen to that again. Engineers who go to the buildings to write a report saying everything that needs to be repaired on this huge building must now also disclose and say, hey, I intend to bid on this work as well. Why? The legislature wants to protect associations from having an engineer, a firm, recommend potentially unnecessary or inflated repairs and then bid on the work. There's a potential interest in a firm saying $8 million of repairs have to be done when really maybe 5 million needs to be done, and then to bid on the work. So now what these firms need to do, they need to disclose it and say, hey, I might bid on this. Okay. Does that solve the problem? In my opinion, no. First of all, is there a problem? I would say that the evidence that the legislature changed the law on this is evidence that there is a problem. Okay, what is the problem? You suddenly made every condominium association in Florida, well, not every, but most of them now potential customers for these firms. Okay, and there's a huge ability for these firms to make a lot of money from these repairs on these buildings. So the question that I ask as a lawyer, again, one lawyer's opinion, is why should engineers or people who inspect properties be allowed to bid on the work at all? Why don't we have two separate classes of people, inspectors, and then we have the people who do the work? Because while the disclosure does help, an engineer or inspector saying, I will bid on this work, a lot of times it doesn't help, because unfortunately, a lot of times boards are not properly equipped to negotiate construction contracts or contracts of any great scale. Many times, board presidents will just go with the firm that was friendliest to them and they like the most. So there's a lot of issues happening here with this. I would say the pro tip here is if you are a board or an association and you have these milestone inspection studies and these recommendations for repairs, scrutinize it, okay? Potentially, as I'll go into later, form within your association a construction committee, board members with or unit owners with experience in construction and contracts can review this and counter and save associations millions of dollars. Okay. All right, so there are penalties for this, okay? If a engineering firm or inspector does not disclose this, the association has the right to terminate the contract. Okay, individuals who violate these disclosure rules can face professional discipline from if it's an engineer or an architect, whichever licensing committee regulates them. Okay. All right, now to go into something pretty related, okay? It's reserve funding changes. All right, so what did our Florida lawmakers do? Okay. Before, okay, when the structural integrity reserve studies were being done, items items requiring, arguably over $10,000 in repairs, or that would need $10,000 or over in repairs, needed to be included in the structural integrity reserve study. So if you had a gate which cost $10,000, to repair or maintain, before that, the person conducting the study would put that in. Now the threshold has been raised to items over $25,000. Okay, the point of this is that smaller ticket items can be handled through the operational budget. So this is to focus reserves on truly substantial components. Okay, pro tip, associations may be able to save money by doing repairs continuously and before milestone inspection and structural integrity reserve studies. Okay, don't go into these studies and these inspections with your building being a mess. Okay, because everyone is going to pay. And at the rates of how big these special assessments are, it affects each unit owner in a very significant way. There's a big difference of a $5 million special assessment versus a $10 million special assessment versus a $1 million special assessment on buildings with 100 or 200 unit owners. It could really affect people's lives and their ability to remain in their unit. Okay. So it's part of, board members' fiduciary duty to continue to do that. You're essentially, when you're a board member, okay, you're essentially running a company. An association is a corporation. It's a not-for-profit corporation, but it has certain duties, and your duty is to your unit owners. They're like your shareholders. So you are charged with trying to be the best director you can. Just as if the same as if you're the CEO of AT&T or Coca-Cola, you have to negotiate these contracts well. And if you don't know how to do so, go to somebody within your organization who does. So temporary reserve funding pause, okay? So there's new flexibility under HB 913, not only for performing the structural integrity reserve study, but for actually funding the reserve contributions. So what the law says now is owners cannot vote to just waive reserves. You cannot say we're running without reserves in this building, but associations that have completed their milestone inspection may now pause or reduce certain reserve contributions for up to 2 years, giving flexibility to redirect funds to urgent repairs, okay? So again, if you have already completed your milestone inspection, you may pause or reduce reserve contributions. The purpose is so that instead of, say you as an association just got your milestone inspection study done. It says you need $1 million worth of repairs, to get this building in order. You also need to fund $1 million or $2 million in reserves. You can pause the funding of reserves to redirect that money into fixing the building. Okay, into fixing the building. And then when you fix these things, you will update the reserve study. So it's the relief of not having to fund this right away and being able to lower how much you're ultimately going to have to fund in reserves. There's certain requirements. Association must be owner controlled. Okay. A milestone inspection must have been completed in the past 2 years. All right. It has to have been a legitimate inspection with identifying repair needs. And it requires a majority approval of all unit owners to do this. Okay. And it could be paused for up to 2 consecutive annual budgets. And like I said before, funds that would have gone to reserves can be used for the necessary repairs. Okay. So again, I said before, unit owners associations are being hit by, three angles. This is shutting off one of those angles, pausing that, okay? All right. And the Florida lawmakers also added another option, okay? So with regard to funding those reserves, instead of just getting it all from their unit owners, if they have to get $1 million of reserves and they have 100 unit owners, instead of charging everybody, 10,000 or so a unit, I believe the math is correct on that, hopefully. Then they can instead do a special assessment, get a bank loan or a line of credit, okay? Bank loans and lines of credits will be much more useful because you could spread that amount over the time. You already see this as a unit owner. Many times special assessments happen, and to give you the option, you could either pay this much upfront or you could pay it over 4 years. That's because your association got a loan or a line of credit. So associations can now do this for their reserve funding, okay? It's an option they can do. All right, this is to give again more flexibility. It's a financial relief bill, okay, for associations. There's certain requirements. It must cover the full reserve amount, including past shortfalls, which makes sense. So, an unscrupulous association can't just go borrow 50, 100,000 or whatnot, trying to piecemeal this. They really want people to fund the reserves. It's still a safety bill. They want buildings to be able to complete repairs. And it must be fully accessible to the board and it must be disclosed to buyers. Any buyer has to know about this. It has to be in the annual financial statements, of course. Okay. Now a section on CAM license and management. Okay. Now I asked the audience members here, condominium buildings, some of these have, 300 units, 400 units, multifamily, huge, 50 floors sometimes. What would you think is the proper training for someone licensed to manage a building like that? What would you think? You would think, some engineering background, background in construction, background in structural issues, some background in engineering, maybe a degree in that. No, you would think so, but no. In Florida, the qualifications to become a CAM are surprisingly low. Okay, now this young man you see there in the picture, he may not be a CAM. He appears about 18 years old, but he could be. He absolutely could be, and let me tell you why. Okay, so what is what's called a CAM or an LCAM? You hear this a lot, and it's important for people to know. Okay, we represent, thousands of people, homeowners a year, and we ask, what's the name of your association? Many times they'll say it's First Service Residential, it's Castle Management Group. No, that's the name of your management company. Now, many times unit owners confuse those because sometimes your management company is essentially acting as your board. So, associations can either be self-run, where it's just run by directors, and small associations are typically like this, or a board can hire a management company to perform the functions of the association. Okay, so a licensed community association manager is somebody who's certified by the state of Florida to do so, to manage condominium associations, homeowners associations, and co-ops. Co-op is another word for a type of condominium building. The rights are a little bit different, but it looks essentially the same. Large multifamily building with many different units. So what are their duties? Managing association budgets. A lot of times you see them at meetings, conducting meetings, fines, violations, coordinating maintenance, many times coordinating the repairs after a milestone inspection. So that's quite a large amount of responsibility. They have to know about the Florida Condominium Act. They have to know about what's in the declaration of each condominium. Okay. They have to know about what are the recent legislative changes. They should know about structural issues generally affecting a building and how to, proactively address them. So what is the training? It's very minimal. Okay. So they must be 18, and this is from the statute, okay? It's from 468.433. They must be 18 years old or 18 years old or older. That's scary. I should not have been managing quite anything at all at 18 years old. Must be of good moral character. What is that essentially? Likely a background check, okay? Education requirement, and this is a funny Florida requirement. This is from the statute, not to exceed 24 hours of pre-licensure education. So to be clear, the Florida law says an LCAM cannot get more than 24 hours or should not have to have more than 24 hours of education. Typically, the courses, if you look them up, are really like 8 hours, sometimes 16 hours, the courses that they do. And I want to say many CAMs, this is not against CAMs, many CAMs, there's people trying to do a good job, and it's not their fault that the requirements are that low. And many of them are well qualified and well experienced. Like any industry, they're good and bad, and sometimes people don't have the qualifications but earn them and try to do the best they can. But it is to say that this is a low bar to have for a professional, a licensed professional who is essentially running these large buildings. They have to take a written test. It's a 100-question multiple choice test, and they have to get a 75% on it. That's a C, a grade C on it. And no prior experience in association management required. Okay. That's a little bit scary in my opinion, because what are they doing? What are they managing? You see that there to the right, large multifamily, multi-floor buildings built on the coast on sand with a lot of different issues. Okay. So this is something that I like that the lawmakers did. They really strengthened oversight of CAMs, of LCAMs. So what did they do? Okay, first a 10-year ban on CAMs, okay, community association managers, if they've been revoked. Okay, so if they may not reapply for 10 years, they may not be serve as an employee, officer, director, partner, owner of a management company, and they have to now register their license online, and they must maintain an active online account with the DBPR. So they're really making it so LCAMs now have to register on the DBPR. There's going to be a sort of portal where they list all the associations they manage as well. They have to list each association where they serve and the designated on-site manager. They must update the information within 30 days of any changes. And the DBPR must notify the management firm and any association managed by the CAM if that CAM's license is suspended and revoked. Why is this put in place? A lot of homeowners have a lot of troubles with their management companies. They, have valid complaints and don't know what to do with them. And it's almost like the management companies are sometimes protected by this just lack of clarity between who's in charge here. Is it the board? Is it the management company? So this is it's starting to provide a lot more checks and balances for licensed community association managers. The second change, and this is quite possibly my favorite part, and this I'll go over this in the questions and answers because I saw some of you asking about this. They strengthened oversights. They put this is not really reported in a lot of guides on the new law change, but they put this in here. It's the first thing: legal violations prohibited. And I want you to read that. It's important to know. A community association manager or a community association management firm may not knowingly perform any act directed by the community association if such act violates any state or federal law. Again, in layman's terms, a CAM cannot knowingly do something directed by the association if that something violates a state or federal law. Okay, what are state and federal laws? One state law, the Condominium Act, all these provisions, the structural integrity reserve requirements, the requirement for associations to maintain things like roofs, walls, windows sometimes, and pipes and other structural issues. It sounds like, well, that should be common sense, but in representing homeowners across Florida, the most common situation is this an LCAM knowingly violating the law? We've represented dozens of senior citizens who have been begging for repairs to roofs that are leaking into their units for years. Just begging the association, will you stop the roof from leaking? And the LCAM will just say, we're working on it, or we'll misinform them. That's not allowed anymore. An LCAM cannot, if their association says, don't repair the roof, and they say, okay, we're not going to repair it, that's a violation of a state law. That's a violation of the Florida Statute 718.113, which says associations have to maintain common elements. But there's other laws. CAMs cannot not now refuse to give documents. They can't participate in that. Okay. So essentially a CAM cannot now say, I was just following orders. That is gone as a defense. Okay. They have to provide mandatory support for building safety laws. So this is kind of putting CAMs on the hook as well. Like you have to make sure that this building's going through all the milestone inspections, all the necessary repairs as well, okay? A contract with a community association manager cannot waive or limit their obligations. Okay, they can get immunity from this or indemnification from it or something like that with regard to their professional obligations. Okay, and there's also, this is a strange facet of this, but the legislator changed this law to make it so they cannot just follow orders and break the law. But within the licensed community association manager statute, any person who violates any provision of that statute is guilty of a misdemeanor of the second degree. So within the statute, which governs community association managers, okay, which starts at, I believe, 468.4334 around there, okay? You're going to see a section which says that anybody who violates, any CAM who violates any provision of this is guilty of a second degree misdemeanor. A second degree misdemeanor in Florida is punishable by up to 60 days in jail, okay? And I believe up to 6 months of probation, all right? Now, whether police agencies are going to pick this up and start arresting CAMs is another story, but it's important to know there is a law on the books on this. All right. And now some governance changes. It wasn't a lot, but some interesting stuff to know about, which may affect us, coming out of COVID recently. So there's expanded emergency powers. Boards can now require residents to evacuate during any type of evacuation order. Boards before the law change would be able to require an evacuation during a mandatory evacuation. So if Miami-Dade County issued a mandatory evacuation, then boards were able to do so, okay? Now, though, they can do so during any type of evacuation order. So they can, if they're, which is important, if they're in a coastal community and it's a small building or a certain building with certain issues, they can, if there's an evacuation order an evacuation of all the residents. You should know that, Florida hurricane season, and we're going into that this could happen, okay? All righty. So let's just go on to the next slide. And associations are immune from liability for non-compliance. So if you choose to stay in a building, they're generally going to be immune from civil liability for that. The next thing to go into is insurance requirements. This is kind of minor at face value, but major, okay? Condominium associations now must carry adequate property insurance. The legislature changed it to make it that they shall carry the necessary insurance, okay? So that's important because, like I said before, we've represented homeowners who there's buildings and their board presidents refuse to get the building insured or refuse to do the things to get the building insured, believe it or not, which makes it that and nobody can really sell their unit. The maintenance is being, neglected and whatnot. So this allows both condo association boards and CAMs potentially to have liability for not getting insurance and not doing the steps to do so. In that situation now, with if a unit owner has a board who refuses to get insurance, they could file a lawsuit to force them to get that insurance, okay, and to go through the steps on it. All right. The next section is on financial transparency, okay? There's some more new records that you can access as a homeowner, okay? First, all bank statements and ledgers now have to be maintained as a record. Why is that important? Okay, many times unit owners request records and they just get some type of financial statement or a profit and loss or whatnot. And when they ask to get the actual bank statements and ledgers, they are refused. Now, this is within the documents that will have to be posted online if your association requires a website or be accessible to unit owners. Also, affidavits that, board members have to sign saying that they've received structural integrity reserve studies and whatnot have to be kept. And before, an annual budget has to be posted online. Before, there was some lack of clarity as to whether a budget or financial statement had to be posted. Okay, video meeting recordings. If there's video recordings, they must keep these for 1 year after the date they are posted online. Recordings of the board meetings of the association of the board. Okay, and any newly created received record must be posted within 30 days of receipt, okay? So enhanced website requirements, we get this a lot, okay? Does my association even need a website? Are they required to have one? This is what the law is, okay? And it's changing at the end of this year. Before, okay, associations with 150 or more units must maintain a secure website. An amendment made it that by January 1st of this year, of 2026, so at the end of this year, condos with 25 or more units must have this website, okay? And they have to post quite a bit of things, okay? What this law changed was adding a couple things they have to post, but this here is everything essentially that they must now include on their websites, okay? Important things there, annual budget, okay? Conflict of interest disclosures, bank statements and ledgers, okay, all of that you're going to have access to, and you should have access to. It will be illegal if they don't post this. All right, resale disclosure requirements. Okay, now homeowners will have 7 days to review the condo documents and cancel their purchase instead of 3. Might be of interest to realtors out there. Okay. Electronic voting and video conferencing, very important, okay? In South Florida, a lot of the problems people have with their buildings is that there's limited access. You know, sometimes we represent people who tell us or tell me, Michael, my building's being misrun, okay? I don't know what to do. All right, and the problem is that all the other unit owners don't know what's going on. They live overseas and they can't really, they're not involved in it. So what did the legislature do? They made it a little bit easier for people in those situations to participate, okay? So board and owner meetings may be held in person, by video or video conference. If held by video, a physical meeting location must still be provided. You know, some people don't use Zoom and whatnot, so for certain seniors or whoever who like in person, they have to provide in-person location. There's rules whether with regard to a quorum, at annual meetings, okay? A majority of board members must still be physically present at the meeting to establish a quorum for an annual meeting, okay? Remote board members can vote, but don't count towards the physical quorum at the annual meeting. All right, the meeting notice requirements has to have, you know, the web link and everything you would think. All right. And we also changed some electronic voting requirements, and this is really great for boards, okay, for unit owners. So what the law says is if 25% of the owners petition for online voting for the next scheduled election, 25%, okay, the board must hold a meeting within 21 days to adopt this. Okay, associations, so there's two things, it's kind of confusing. There's electronic voting and they're submitting votes by email, okay? So submitting votes by email, there's a provision for that as well. So again, so modernized voting access, you could do an owner petition for online voting. If 25% or more owners sign the petition, must be adopted. You have to have a meeting to adopt it within 21 days. But there's also the email voting options. Associations must now accept votes sent by email, okay, not through the electronic voting platform. And they must designate an official email address. And there's certain requirements on it, but it's making it so if you're not present, you could still vote. Okay, they cannot exclude people just because of they're living overseas or whatnot. Okay. So key takeaways, everything I said, you have some greater access to financial records, you have easier participation, you have stronger oversight, more flexibility, targeted relief, and new protections against conflicts, okay? And the implementation timeline, okay? Website requirement at the end of this year for 25 units or more. This year's deadline was the structural integrity reserve study deadline was extended. Electronic voting, the timeline for that is when the petition is put in and then the board puts in a meeting within 21 days to adopt it. The general effective date for most all of these was July 1st. Okay, so most of this is already effective. All right. And almost lastly, my 2 cents. Okay, this is from The Simpsons. I don't know if you remember Kent Brockman. I definitely grew up on it, but this is what I tell pretty much everyone who owns a unit. All right. Remember, you own an asset. All right. You own something that has value. That's part of your worth, your net worth, you know, and you have an asset, so you need to protect it. Okay. One of my favorite sports in the world is boxing. See the boxing gloves up there, not mine, they're souvenirs, but I love boxing. And one of the things I love about boxing is what do they tell each boxer when they start the fight? The referee will look in your eyes and say, protect yourself at all times. They'll say to both fighters, protect yourself at all times. All right. The referee is there to help and protect the fighters, but the fighter needs to protect himself. So, your board's there to help you, but you need to protect your asset. Okay. What does it mean? Stay informed, get involved if you have concerns. Okay. If you're a board, construction contracts are complex. Form a committee. Form a committee of people who live within your building who are former developers, contractors who could analyze this. We've seen things that are quite exaggerated on these contracts. All right. Do your due diligence before you buy a unit. Okay. You can review the association documents, see what they are responsible for, see how many amendments they have done. Are they really trying to amend this to make it not good for unit owners? You could consult with an attorney on this before to really look into the association. You could check the court docket to see if that association is being sued or has been sued. All right. All right. We're still going. All right. And if you lose trust in your board, you can take action, okay? Owners can evaluate, can do a recall, okay? This is something whenever somebody calls me and says, my board is going crazy, I don't know what they're doing. The first question I ask them is that if a vote was held today, okay, if a vote was held today, would that board win the vote? What does it mean? If 100 unit owners had a vote, would they win? If those unit owners tell me no, they would be voted out immediately. The unit owner should consider a recall to recall those board members, install a new board to start properly analyzing these contracts, take the proper steps. Okay. It's the most powerful tool, and unit owners should really know about that. This is not, although an association is like a government, in some ways, a small government, it's not like our government where you have to wait 2 or 4 years for an election. This is part of the checks and balances. If a board is not doing right by its board, to its unit owners can take back control with essentially a majority of vote. Okay. Lastly, know your rights and enforce them. Okay. If your unit is being damaged due to building-wide structural problems, do not wait for the association to fix it. Associations rarely fix interior unit damage voluntarily, and statute of limitations can expire. Timing matters, okay? We offer free consultations on those cases of property damage affecting units specifically because we have a streamlined system of helping unit owners with this, and we've helped many vulnerable people, especially seniors. We love our seniors and our veterans here at Perez Mayoral, PA, and always try to help them however we can, okay? So now is the time that some of you may have waited for. Okay, it's questions from today's attendees. Okay, and let me pull these up. If you just bear with me, I reviewed them before and was able to go through them and give you some preliminary answers. Okay. All right. The first question I have here is, does the milestone inspector in Florida, okay, have to perform a visual inspection of each individual unit? The answer is kind of unclear, okay? The milestone inspector must perform a visual inspection of both habitable and non-habitable areas, but the Florida statutes don't specifically require a unit by unit check, okay? What does that mean? It's not helpful. It's not helpful because sometimes, the problems are within a unit is suffering damage, okay? So damage to a unit is another story. My 2 cents on this, if you have damage to your unit, you need to speak to an attorney. Why? Associations just rarely fix the damage to the inside of the units. They will go through a layer of denial, first telling, people who call us at least, first telling them that there is no damage to the unit. Then if there is damage, then the unit owner should fix the inside, no matter who caused it. And then telling the unit owner to call their own insurance and just essentially denying fault. And we see unit owners having a lot of trouble with this. So damage to your unit is another story. If your regress is potentially contacting the building department, okay, or contacting a lawyer. This is one of the big parts of what we do. We sue condo associations for failing to maintain buildings and damaging people's property. And we like doing it, and I believe we get good results for people on them. Okay. The next question is, how is it determined if condo board responses to owner questions are satisfactory and non-evasive? Again, how is it determined if a condo board response to a unit owner question is satisfactory and non-evasive? So ultimately, that would be decided by a court, if that comes to light. It could also potentially be decided by the DBPR. Okay. So in Florida, this is something really important to know. Many times our clients call us and say, I've been asking my association about XYZ, and they just won't tell me anything. They won't answer my questions. I've asked them for documents and they won't give me documents. So this is something that I would say bad associations and bad management companies do. Normally, if someone just asks for a document or asks a question, you should answer it. But what some associations do, or management companies, is they don't answer the question unless it is done in the correct legal way and they are forced to, or they obligated to. So in Florida, there's this thing called a written inquiry. What the Florida law says is if you submit questions to your association via certified mail, okay, they must respond with a substantive response, okay, within 30 days or 60 days if you're seeking approval of counsel. The DBPR also has some jurisdiction over written inquiries and associations responding to them. Also, if associations fail to respond to those written inquiries and there's ever a lawsuit, the association is forbidden essentially from collecting attorney's fees if they fail to respond to those written inquiries. Okay. So this is a tool that you can use to get questions answered by your association. Many times associations just send these questions to their attorneys, and sometimes unit owners get a better response because an attorney sometimes is more responsive and will look into the legality of the issue. Okay. So just know written inquiries, you could absolutely do this. I have information on my website about demanding documents and information from your association. Okay. Next question, well, this is a double question, and I'd like to address it, and we went over it before, okay? It's, can a management company be sued by residents for withholding association funds? The second question is, can the management company be held liable for carrying out illegal activities directed by the board? The answer is, as we went into before, okay, that yes, now licensed community managers cannot just follow orders and say that they were doing what the board asked them to do. I'll just reshare the slide with you just so you see it. But right here, a community association manager or community association management firm may not knowingly perform any act directed by the community association if such act violates any state or federal law. So if a management company is carrying out illegal activities directed by the board, that is right on point. It is illegal. They cannot do it. It's a violation of the statute. It's potentially a criminal violation per how the statute reads as well. Okay. The next question we got is email acknowledgement legally equivalent to certified mail for triggering the 10-day period for access to condo official records? So what this listener is asking is that I sent a records request and they sent an email acknowledgement saying they got it. Is that enough for triggering the 10-day period for access to condo official records? Yes and no. Ultimately, if you want to take legal action about it later to force them to comply or to put fines, they had to have received it via certified mail, US certified mail. With regard to sending questions and record requests to your association, US certified mail is your best friend. It costs between $1 and $1.50 per letter. It provides you a tracking number, and this is all that's required. Not FedEx, not UPS, United States certified mail at the post office. It's a little green slip, very cheap. Just write any questions you have to the board, send it via certified mail. Any document requests, send it via certified mail. You could then really enforce your rights, okay? Next question, do condo homeowners still have to pay special assessments under the new legislation? Yes, absolutely. Unfortunately, the money has to come from somewhere. So that's part of the to and fro of it. Your building needs maintenance and the money has to come from somewhere. Many unit owners want it to come from the board members. They want to say, well, the board members were negligent. They should have to pay for this. Generally, the law doesn't generally provide for that, and it's a very difficult lawsuit to maintain. And so generally, yes, you still have to pay for special assessments, subject to whether the special assessment was passed correctly, proper notice, whether it's legal for them to do it under the governing documents and the association. So there's a lot of steps as to compliance with that. But if it was all legally done, then yes, you would generally have to pay it. Next question was, are board members allowed to keep voting themselves into office without proper elections, especially in small associations? We actually see this all the time, not necessarily voting themselves into office, but there's a problem when it's a small association, say 8 or 10 unit owners, and there's not a lot of people competing to be on the board. In a lot of those situations, you'll have the same board for quite a while. We've also seen boards try to use loopholes to keep themselves on, to keep people off the to block people's candidacy. You know, eh, eh, what I like to tell people is condo associations is like this grand psychological experiment where you put people into these little groups of 5. You know, you pick 5 people off the street and tell them to run a large organization. And lo and behold, some are very well run, others turn into banana republics. Okay, so you do see that the general answer is it depends on what's in the governing documents and exactly what they're doing and how. Okay. Um, Next question, which might be one of our last ones here, which is very important. What happens if a board refuses to comply with a DBPR order to turn over association documents? Excellent question, very important, okay? There's civil penalties and fines, okay? There's generally, I believe it's $50 a day up to 10 days, beginning on the 11th business day after the request, okay? More importantly, okay, there is they've turned these into misdemeanors, okay, and felonies. So it is a second-degree misdemeanor, okay, for knowingly, willfully, and repeatedly violating the requirement relevant to records inspections. You go ahead and pull this up so you can see the exact text. But essentially, it's a second-degree misdemeanor, which is punishable by up to 60 days in jail, to willfully refuse to turn over records. Okay, it's a first-degree misdemeanor, which is punishable by up to 364 days in jail for intentionally defacing the records, okay, with an intent to cause harm. It's a third-degree felony for someone to refuse to release records with an intent to avoid, escape, detection, arrest, trial, or punishment for a crime. They're essentially treating it like the crime of tampering with evidence, okay, which is a crime as well. So there are criminal violations essentially to just refuse to do so. And generally with any criminal violation, your next step is either to go to the police or to your local prosecutor's office. Some state attorneys and prosecutors' office have what are called economic crimes divisions within them that handle these things directly. Otherwise, you'd go to the police. Okay. All right. So this has been the conclusion essentially of our presentation, but I'd like to leave you all with something else quickly before we leave, okay? All righty. All right. So we are Perez Mayoral PA. I want to say how we help, and I want to provide ask some questions and provide some information about our next call. Okay. So what we do very proudly, we represent homeowners against their condo associations and HOAs in Florida. I have to tell you, being a lawyer is not always easily, and I haven't always loved what I do, but I really love what I do. We really love representing homeowners here. It's extremely rewarding work to help people who need help. There aren't many firms who do what we do. So if you're in need, we try to help the best we can. Common issues we handle, failure to maintain common areas, what we're dealing with here, associations failing to do repairs. Also property damage from them failing to do repairs. If someone's unit is damaged by a pipe burst, roof leak, associations tell them they won't pay for it. We get them to pay, and every case is different, but that's what we do for people under the right facts, under the right law, where, we have been very successful in getting people to pay for these property damage issues. Governance and transparency issues, rule and covenant disputes, architectural disputes, assessment disputes, selective enforcement, discrimination, harassment, leasing and buying issues. We help realtors who are trying to get people approved who are being wrongfully denied. Neighbor disputes between neighbors, and accidents and personal injuries on HOA property, negligent security, or, if someone's injured, we handle that as well. What I'd like to ask is this: we really, part of why we do this, we really want to inform homeowners. We want to give you all the tools that you have. So I'd ask, if you enjoyed this, please give us a review. Please review us. Tell us if you enjoyed it. And more importantly, in that review, let us know what you'd like to learn about next. Okay. We don't know what the topics you all favor are. Some people have told us we want to hear more about HOA. Some want to hear more about this. Let us know what you'd really like to hear more about next, and we will do our best job to give you really a comprehensive learning experience as to it. Okay. Again, this has been Michael Peter Mayoral from Perez Mayoral, PA. I thank you so much, all of you, for attending today's meeting. We are yourhoaattorney.com. Okay. The website and the phone number is there. Do not hesitate to contact us if you have something you need help with. Again, thank you again and have a great day and best of luck, okay, dealing and navigating this condominium sphere we're in, okay? The law is changing and there's some pressure on condo associations, but your lawmakers are trying to do the right thing and trying to help things. I personally think the condo market's going to be just fine, okay? So again, best to everybody and thank you again. Have a great day, everybody.